Hello, everyone. It is Heather Reid here. I'm honored to be here with you today. My pronouns are she, her. And for those folks with using accessibility technology today, I'm a 60-year-old white female sitting in my home office with wall-to-wall bookcases behind me. I'm wearing a navy blue blouse. I have ash-colored curly hair, and I'm wearing red glasses. Now, before we jump into today's topic, I need you to know that I am not legal counsel, and the discussions here today do not in any way reflect that I am providing or suggesting legal advice or legal language. And the second thing is I know that you're going to have questions now or during the replay, so please don't hesitate to put them in the comments wherever you are viewing this, and I will do my best to get back to you either today if I can, or in future episodes, or wherever you leave the comment. So today we're discussing case studies in force majeure. I think it would be insensitive of me today if I did not take a moment to acknowledge the real world force majeure-like events that are currently impacting our communities and the events industry. These are more than just contract terms. They are the lived realities of so many people, including our industry colleagues. I would ask you to reflect on the resilience of those affected and to consider how our work as event professionals can adapt and respond to these challenges with compassion and with responsibility. So let's use the next 25 minutes to not only deepen our understanding of force majeure clauses, but also to think about the broader context in which we operate. So, a contract is a legal instrument used to allocate risk between parties. I like the word entities. In our industry, the parties or the entities are typically a client or group and a supplier. And force majeure is a legal term that refers to an unexpected or extraordinary or unforeseen event that prevents one of those entities or parties to the contract from fulfilling their contractual obligations. And the term is French for superior force. And I almost wish it was superior force because I don't say force majeure all so well. In a contract, the force majeure clause is the clause that is intended to remove liability for catastrophes that are preventing one or both of the entities from fulfilling their obligations. A force majeure clause generally covers natural disasters like hurricanes, tornadoes, and earthquakes, and human actions such as armed conflict and human-made disease. A force majeure clause should answer in writing in your contracts the following three questions. What constitutes a triggering event? Second, what impact must those triggering events have on the entity who is invoking the clause? And number three, what effect should invoking the clause have on that party's contractual obligations? So I'm going to repeat those because I know that those are questions that you should be thinking of when you review proposed language and when you're working with your legal counsel. And I know that they've been put in the chat as well. So number one, what constitutes a triggering event? Number two, what impact must those triggering events have on the entity that is invoking the clause? And number three, what effect should invoking the clause have on the party's contractual obligations? So I know the title said case studies in force majeure, but in preparing for today, I can't do justice to more than one case study. So I'm going to use just one as my teaching tool for today. And in these broadcasts, I'll come back to the other one someday. So the case study that I want to share today involved a hotel contract for an international weather-dependent event. Now, you may already be thinking, well, I don't plan international events. I don't plan weather-dependent events. However, I want you to stay tuned because what I know for sure is that the lessons that I share here will still apply. So, to give you some context, I was hired to review the hotel contract for a national sporting organization that hosts international sporting events. It is an outdoor sport and it requires specific and conducive weather conditions. And in this case, snow and lots of it. So the hotel contract was being negotiated to house the athletes and the event staff, as well as conduct meetings and social functions. And the organization was hosting 2 sporting events back to back at the same sporting venue. So that's the context. So when I get the contract, I read it, and in my written review, as I always do, I create 2 types of comments on the document. So first, I included comments and requests that were directed to the supplier, in this case, the hotel, that I knew that the client needed to have included in the contract to balance the contract and balance the risk and protect the client. And I also included comments that were notes or questions or concerns to the client. So when I came to the language that referenced force majeure, I found very typical boilerplate, actually short language. And I debated whether to throw it in the comments, but I don't want anyone knowing that this is good language and I'm not providing it to you, but I will read what this hotel contract said verbatim in draft form. It said, this agreement may be terminated by either party without liability upon written notice within 5 days if a party's performance under this agreement is subject to acts of God, war, government regulation, terrorism, disaster, strike, civil disorder, a travel restriction issued by a governmental agency, curtailment of transportation facilities, or any other emergency of a comparable nature beyond the party's control that in each case make it illegal or impossible to perform its obligations under this agreement. So this is typical language that we see, and I am going to repeat it for you, but I don't want to put it down in writing because it's not sufficient. It's not bad language. It's not sufficient language that helps clients protect their events. So in essence, it said that this agreement can be terminated by either party without liability. It had to be written notice within 5 days of the force majeure event. And if the party's performance is subject to things like acts of God, war, terrorism, strike, civil disorder, curtailment of transportation facilities, and that it makes the performance by that party illegal or impossible. So, does this actually reflect the situation that the client is in? This is an international event. It is a weather dependent, and in this case, I just saw Joan's comment about aren't all events weather dependent. In fact, they are. The ability to get to them, the ability to host them. This one required a advanced good weather to provide snow. So there had to be a certain threshold there for the event to proceed. So I had numerous requests for the hotel's consideration. I have 4 that I want to share with you today as teaching points. First, I asked the hotel to include language that expanded the words subject to in order that it was broader so that unforeseen events beyond what they listed could be considered as a triggering event. So, subject to acts of God, war, strike, etc., seems quite narrow. And it had gone on to say that it had to be of a comparable nature. Well, in none of that was there a weather-related trigger. So the event was international. The client needed to be protected against borders closing, against curtailment of international travel, the inability to secure visa entries for the athletes. And so we needed to work with the hotel property for them to create language that addressed those possibilities. And the client was at a potential risk of not being able to fulfill its obligations of this particular contract if the sporting venue was unavailable due to matters beyond its control. Because this was just a housing contract, the sporting event was being held elsewhere, and the force majeure clause didn't address anything about the other facility and the impact of its unavailability to this contract. So the sport venue required a scientifically demonstrated amount of snow to be able to host the event. So there was a really good, strong connection in case it needed to be made. What if the venue was not available? And my teaching point is you may have heard me talk like if you're hosting an event in hurricane zone in hurricane season, you're supposed to have hurricanes listed as a triggering event because a reasonable person would expect that there would be hurricanes or there could be hurricanes. So in this client's case, they knew that they needed a minimum threshold of snow. So that's the first point, was subject to. Let's make it as broad as possible so that something that's not written as a possible triggering event can be considered. The second point was I asked the hotel to include language that expanded the negative impact on the client to include the condition of impracticable in order to supplement illegal or impossible. It is my understanding as a layperson that illegal and impossible are strictly defined legal terms and have very specific and high thresholds for the client to meet in terms of their ability to, or their inability to host an event. So by asking the hotel to include language that addressed the condition of impracticability, it allowed for the client's performance to be negatively impacted for reasons beyond their control, but not necessarily either impossible or illegal. So that's the second teaching point, is that we move beyond impossible or illegal and really advocate for the condition of impracticable. And then we have the third element that I asked for. I asked the hotel to include language that indicated that the client had up to 10 business days, not 5, to invoke the clause after a force majeure incident. I worked with associations for my entire planning career. Trying to get major decisions made within 5 business days was next to impossible. And we all know how difficult it can be sometimes to get consensus on emerging situations. So we doubled the amount of time that decision making could be made by the client. And then fourth, I asked the hotel to include language that addressed partial performance by the client despite a force majeure event. So I'm going to repeat that. I asked them to include language that addressed partial performance by the client despite a force majeure event. So this language was requested for the hotel to create to protect the client should they be impacted by a force majeure-like event, yet the client still decides to proceed with a reduced size event. So under these conditions, the client may actually underperform its original responsibilities for guest rooms, for meeting space, for food and beverage, but the client should not be penalized for such underperformance because the originating circumstances were beyond the client's control. And this underperformance due to force majeure is not the same as attrition. So that was the fourth, and what I really considered to be probably one of the most important is that we're always thinking of, we may, like when we came out of COVID, for example, some events were able to be held, but they were significantly hampered by the number of attendees that they could host. And so any attrition damages, they're not attrition damages because it's not at the client's capabilities to fulfill that contract. A force majeure-like event has made it more burdensome. So those were the four of the ones that I wanted to share with you that I asked the hotel to consider on behalf of the client to make that language more balanced and to protect the interests of the client. So after all of the negotiations were completed, the hotel contract was signed and countersigned in September of 2023. The event was scheduled for the end of January 2024, so just about a year ago. At the beginning of January 2024, on the 10th, I received an email from the organization indicating that the sporting venue was only able to provide enough snow to host one of the back-to-back events, which would dramatically decrease the number of sleeping rooms, would decrease the meeting space and the social function space that the client required. The sporting venue had agreed to provide written documentation to the hotel that rigorously laid out the industry standard minimum requirements of natural snow, their ability to manufacture snow, and that it could not possibly host two back-to-back events while maintaining the integrity of their product, which was snow and a base for this sporting event. So I was able to help the client put together the business case for them to invoke the force majeure clause and to request the ability to proceed with a reduced sized event without a negative financial impact. And so I want to highlight how those four items that I shared with you, how they helped. So the first one, the client was able to cite the sentence that the hotel created in the negotiated final contract that said, this clause also applies if the host venue for this event is unavailable due to matters outside of the venue's control. That was a sentence that we worked really hard with the hotel to protect the fact that the client was signing a hotel contract that was contingent on the execution of the actual sporting event. So, lesson here, if you're doing connected contracts, connect them if possible. Second point that I had requested, The client was able to use the premise of impracticable to support their situation. The situation was not illegal. The situation was not impossible, but it certainly was more burdensome to the client because of what was going on at the sporting event. And then the client was able to use up to the 10 business days that was necessary to get their decisions and their supporting documentation in order. And finally, number 4, which I think is so important, the client was able to cite the sentence in their negotiated contract that said, the parties will work to negotiate an amendment to this agreement setting forth agreed upon adjustments to accommodate the modified program, which may include decreasing rooms, food and beverage, and concessions. That is language that the hotel provided at the prompt of our situation saying, hey, if we need to go ahead with a smaller event because of something beyond our control, we need to be able to minimize the financial impact. So while I was not a part of the final decision making regarding the actual size of the final event, I had calculated for them that for sleeping rooms alone, they would be relieved of over $100,000 in damages. That is a lifeline for most organizations. So I'm looking at the time. It looks like I have like maybe 5 or 6 minutes left. I'm going to encourage you to throw any questions in the comments. But I hope that this particular case study in a short little, condensed format shows you the impact that thoroughly and strategically negotiating in this case, just one of the clauses in this organization's event contract, the impact that can have. So I'm just going to take a look here. So Will asked, have you found frustration of purpose to be something valuable to try and include in hotel agreements? So Will, I am not a lawyer, and my understanding of frustration of purpose, yes, we are encouraged by our hospitality legal folks and the educators that yes, we should be outlining what is the premise, what constitutes why we are holding this event, and what would exacerbate this event if things didn't go perfectly. So I'm trying. Frustration of purpose is that the fulfilling of the contract has been made burdensome by an external factor. So we are encouraged to add that, and I would do a better day. So maybe I should just do another segment on that because I'd be better articulate it. But yes, the legal educators in our industry encourage us to use frustration of purpose. And where you would put that and where it could be defended is when you use a purpose of the event clause in the contract, or you attach an attachment to the contract that has your purpose of the event fully outlined. There are a series of 9 questions that I'm aware of that a client can use to really build out why this event is being held, who this event is for, where are attendees coming from, what are the risks associated with this, the known risks, what would make this event frustrated in trying to present it. So I hope that answers your question, Will. I want to leave you with 2 things. When COVID struck, I reached out to a colleague of mine, and we interviewed 38 Canadian professional event planners, and we did a study of those 38 planners and the events that they were currently working on that were impacted by COVID. And we did a full report, and we have videos, and it's on a website called chroniclinglessonslearned.ca. Now, I'll spell it because chronicling is such a fun word. Chronicling, CHRONICLING, lessons learned.ca. There is a free report there you can download. You can watch all of the videos, and it'll give you a lot of insight into a force majeure time in our industry that planners live through and how they work through that. And the second thing is in regards to our colleagues today, searchfoundation.org. For almost 30 years, Search Foundation has provided funds to provide financial assistance to event, meetings, and catering professionals who are faced with a life-threatening illness or catastrophic occurrence. I've made a donation, and if you are able, perhaps consider searchfoundation.org. So I think my time is up. I'm actually just allow me here a minute to just go back up in the comments. Yeah, I'm not seeing any. What I do know, you can reach me at heather@plannerprotect.ca, and I hope you will reach out if I can be a sounding board, a resource. If you can put my expertise to use, that would be great. So thank you for tuning in today or wherever you are. Thanks, be safe, be kind, and until next time, folks, happy contracting. Bye for now.